Hello and welcome. My name is Ashley Hawes, and I'm the Director for Consumer Information at Benjamin Rose Institute on Aging. Thank you for joining us today for Discrimination in Employment, the Eras Tour, for a lively conversation on the evolution of age discrimination in employment laws, with a focus on hot topics in the field, including the impact of technology and artificial intelligence on opportunities for older workers. This webinar will be recorded. You may submit a question at any time using the Q&A or chat feature on the bottom of your screen. We do have staff monitoring both to convey your questions to our presenter and to answer any technical questions you may have. In addition to the Q&A session at the webinar, you can turn on captions by selecting Live Transcript, the button with two C's at the bottom of the screen. Today, we have the pleasure of hearing from Bill Rivera, Senior Vice President for Litigation at AARP Foundation, where he leads and provides strategic direction for AARP Foundation litigation. Bill manages a team of litigators and legal professionals who advocate nationwide for the rights of people aged 50 and older, addressing diverse legal issues that affect their daily lives and ensuring they have a voice in the judicial system. The team litigates and files amicus briefs in cases involving employment discrimination, employee benefits, housing, consumer protection, health and long term care, and public benefits. Prior to joining AARP Foundation, Bill served as Deputy Associate General Counsel and Chief of Litigation for the Children, Families, and Aging Division of the U.S. Department of Health and Human Services Office of the General Counsel, where he led the legal team in handling matters under the Temporary Assistance for Needy Families, foster care, child support, Head Start, unaccompanied alien children, and refugee resettlement programs. Bill received his undergraduate degree with honors in public policy and American institutions from Brown University and his law degree from Stanford Law School. Bill has served on several nonprofit boards, including as president of the Hispanic Bar Association of District of Columbia. And now I'd like to turn it over to Bob Blancato, National Coordinator of the Elder Justice Coalition, to get us started with a few opening remarks. Bob?
Thank you, Ashley. And the Elder Justice Coalition is proud to be a co host of this webinar today. Age discrimination of any kind is an elder justice issue. It occurs disproportionately in employment. It remains one of the highest categories of complaints logged each year to the Equal Employment Opportunity Commission. Today, we are truly honored to have Bill Rivera address this issue from his unique vantage point of being Senior Vice President of Litigation for the AARP Foundation. In full disclosure, I am proud to be on the board of the AARP Foundation. In simplest terms, Bill is a relentless bulldog, fighting entities large and small who engage in age discrimination. We so look forward to his comments. Thank you. Ashley? Or do I just say Bill? I don't know.
Let's turn it on over to Bill.
All right, Bill, go get him.
Great. Thanks so much, Bob. Thank you to Benjamin Rose as well for inviting me to participate in this discussion about a topic that sadly is of great importance to so many people. Age discrimination, as Bob noted, it's not just wrong, it's also illegal. And so I want to have some fun today with all of you on what is not a fun topic. It's something that we deal with across AARP and AARP Foundation every day as we try to work for and with older adults to help them attain the financial security that they need. And that, of course, often means having a job. So we're going to walk through a bit of the evolution of the Age Discrimination and Employment Act in particular, which is the federal law that governs age discrimination in the United States. But we'll also make note that state laws apply as well. So it will be not overly legally heavy. We recognize the audience is diverse and has broad backgrounds. And so we want to provide the right balance of information so that you have appropriate tools and resources when you leave here and a better understanding of how age discrimination in the United States continues to persist and how we got to where we are and the significant progress that we have made in the law and in policy overall. But there is still so much in law, policy, and frankly, culture and attitudes and stereotypes that many of us have, whether we recognize it all the time or not, that really hold us back from fulfilling the promise that we all should have to each other to enable everyone to play on a level playing field in all aspects of employment. So I'm going to share my screen here. And as I said, I want to have a little bit of fun with this. I am a big Taylor Swift fan. She is very much of the moment. And so wanted to think about age discrimination and employment as we go on over time. So to set us up a little bit, want to share, as Taylor Swift does in her Eras Tour concerts, the opening clock. And so just to give you a sense as to where we're going to go over the next 40 minutes. I will not be 3 hours as Taylor Swift is in her shows, but hopefully it will still be a pretty good time, informative, and I really look forward to questions that you may have come up in the chat as we go on. So first, we'll talk about the current state of labor force for older adults and the prevalence of age discrimination. We'll look at the law before 1967, which is the passage of the Age Discrimination and Employment Act, or the ADEA. We'll go through the legislative eras of the ADEA, the Supreme Court of the United States, affectionately referred to as SCOTUS among many lawyers, and the eras with respect to some of the big cases involving the ADEA. Some current hot topics, including cases that my team at AARP Foundation is leading, and then we'll go a little bit broader into some of the signs of potential discrimination in employment today, some tips for people to be able to handle those potential words and actions that could be discriminatory, and then finally leave you with some resources from AARP and others that can be helpful for you after we leave today. So without further ado, we'll welcome you to the Eras Tour. So we'll start with just a little bit of background information in terms of where we are today. So you can see in 1990, workers over 55 were just 12% of the workforce. And in 2016, there were 22, and they're increasing from there because we know that people are living and working longer. So age discrimination really becomes even more important and greater a barrier for people to obtain that financial security, given the improvements in health and longevity, and both the desire and frankly the need oftentimes for people to work longer than they used to in the past. And we know as well that workers 65 and older are the fastest growing segment of the labor force. So you can see that when we survey people through AARP, whoops, quick on the trigger. When we survey folks at AARP, we see that people identify that they have seen or experienced age discrimination at work. Most 50+ workers have. It remains the #1 barrier to employment for many older adults. And we see that over half of older workers who are looking for work say that age discrimination has negatively impacted their job search. So diving back into the numbers a little bit, 64% of workers over 50, again, having seen or experienced age discrimination, 13% having been passed up for a promotion or a chance to get a job. Promotions are also covered by the ADEA, as we will see. 60% of job seekers are asked by an employer to provide age-related information upfront, whether in the application or the interview process. We'll talk about what to do if you have that experience or someone you know has that experience. And we also know from recent survey of employers this time that when asked if they believe that someone can be too old to be hired, 35% of them said yes. And then when asked what age is considered too old to hire, the median age is 58. Right? So that means that half of the respondents gave an answer lower than 58, which is kind of frightening. And then just to give the sense of the scope of the challenges, just for those things that are actually at the level of the EEOC, the Equal Employment Opportunity Commission, having a complaint filed formally with the federal agency that enforces the ADEA, over 14,000 such complaints filed in fiscal year 2023. So again, an indication that this remains a significant challenge. So we'll move on to an era here of the 1950s or through the 1950s, when we can really see that age discrimination is out in the open. job ads would tell you no one over 35 need apply, no one over 45 need apply. The jobs were very segregated by age, in addition to gender and other categories too. But with respect to age, it was very common to just expressly say that this job is not for you if you are over the age of 40. And I thought this would be a good opportunity to share a wonderful video that AARP had put together to sort of give a modern day take on what was really common practice in up into the 1960s. Can you hear sound?
We're not hearing the audio.
You're not hearing audio. Oh, that's a problem. Why you're not hearing audio on this? Oh, yeah. Why that's not. Chat. I apologize for that. This is one of those things that should. Apologize for not having the audio here, so I guess we will have to go without here unless my wonderful tech support knows how to get the audio to play.
Yes. Reshare your screen and check the share audio box while sharing your screen.
Okay, let me take a look. Sorry as we deal with these technical difficulties. Let's try this again.
It's working.
Hi.
Great, thank you.
Just one question really quick. You're not over 40, are you?
No.
Perfect, great.
Age limit? I'm not under 40. I'm over 40.
We are not serving anybody over 40 today. We're trying to have a little bit younger vibe today. You are exactly what we're looking for. If you're under 40, I'm actually not going to take your order, sir.
Thank you so much for your interest, but
We're just trying something different. You're just not exactly what we're looking for.
every day, age discrimination happens in the workplace behind closed doors. And we wanted to see what it would look like out in the open. So we hid cameras in a food truck and refused to serve anyone over 40.
Are you under 40?
No, this is for my daughter, it's not for me.
Oh, it's for your daughter.
Yeah.
As long as you don't eat them. Okay. Do you promise that you won't eat them?
No, I promise. Yeah.
Okay, okay. Actually, if you could just step away from the food truck since you're not under 40, and I'll bring you the beignets. I don't want people to get the wrong impression if you're standing over here.
Ridiculous.
You guys are under 40, right?
Yeah.
Okay, great. I can take your order. Yeah, absolutely.
Okay, I don't know what's happening.
This is a stupid thing that's starting to get really pissed off.
Yeah, I mean, if you have a specific problem with somebody, then you should say that
Yeah,
instead
screw
of just
you.
saying.
Stupid.
Hey, for real. Okay. Walking away, I felt really upset. I almost started crying. I was updating my resume recently, and I sort of wanted to sound experienced without sounding too old. I was like, oh, I'm experienced, but that's almost not an asset anymore. It's like I have to sound young and relevant.
Older people just don't really fit into our culture.
That's ridiculous.
We actually don't think that this truck is a good fit for you.
I'm sorry.
I was outraged. This stunt makes me want to take action to help others who might be discriminated against because of their age.
One of the very powerful parts of that video is you can see, even in the context of donut, the emotional toll that having that kind of exclusion in your face based on your age strikes for people. But that was really the world that we lived in going into and through the 1950s. characteristics. And as is often the case in American domestic policy, the states are the laboratories of experimentation. And so you start to see more and more states passing laws that prohibit age discrimination in employment. And you can see the growth here from 1955, 3 states having legislation to 1965, getting up to 20 states. And here's a map of what those states looked like in 1965. And so you can see they are around the country, primarily in the Northeast and the West, but also some over in the middle. And that kind of experimentation led to greater interest at a federal level to see whether there should be, as part of the general movement towards civil rights and ultimately the passage of the Civil Rights Statute in 1964 and Title VII and prohibiting discrimination on the basis of race and so on. And so should there also be something at the federal level with respect to age? So in Congress, in 1964, when Congress passes the Civil Rights Act, they did not include age discrimination among protected characteristics. Instead, they directed the Secretary of Labor to study what the implications should be, what is the nature of the problem, and prepare a report for Congress on age discrimination in employment and present it to Congress. And so when you see in 1965, 25% of employers surveyed said they didn't have job applications available to people over 45, and half of employers closed it off at 55. So again, very in your face, just like the food truck. And new hires also were not older. So you can see the percentage of employees who are aged 45 and older were pretty small in terms of new hires in most places, according to the Department of Labor's study. So all of this leads to trying to understand what are the reasons for employers not hiring older workers. So you can see a list of the top most frequently cited reasons for doing that. And several of them have a lot to do with people's stereotypes about older people, recognizing that older workers now may well be different than older workers in the 1960s in many respects. A lot of these are still rooted in assumptions about what an older person, again, older being even into the 40s, can do or not do. A lack of physical capability, a concern that you're going to be too expensive, that you don't have skills, education, or experience, and aren't able to learn new things, that you aren't going to be working very long, that you're not going to be adaptable, and so on. And so I think this next video gives a good example of the kinds of stereotypes that sadly are still with us and continue to require our vigilance as we look to not only law, but policy and cultural change and changing attitudes in our culture.
Hey, how's it going? You can stand right there, that's your mark. How you doing?
I'm great, how are you?
Great.
Awesome.
Just tell us your first name and your age.
My real age?
My name is Paolo, I'm 25 years old.
My name is Daniela, and I'm 19.
24. 35.
31. 33.
I'm 26 years old.
What age do you consider to be old?
Late 40s?
Maybe 50.
I feel like 30 is a new 20, so I'd say like 40 is old.
I'd probably say 50s.
I'd like you to show me how an old person would cross the street. Show me how an old person would send a text message. How might an old person do a push-up? What about jumping jacks? Okay, hang on. There's someone I want you to meet.
Hello, I'm Birch. I'm 66.
Hi, I'm Daphne, and I'm 68.
I'm Dee, and I'm 55.
George Fassbinder, 75.
My name is Parvati. I'm 70.
Nice to meet you.
Nice to meet you.
We're gonna give you about 2 minutes to teach each other something that you are good at.
I can teach you a jump that I do.
Okay, please.
Both of your legs go up, and your arm goes up, and your left arm goes like to the side. Ready?
Okay.
1, 2, 3. Lift 1, 2, 3. And bring it to your heart. And bring it to your heart. And head in. Yeah.
You want to try to get your balance and raise up. Now, you can bring your legs and your feet up. It's hard, right?
Yeah.
1, 2, 3, 5, 6, 7. So when you come out of a turn, either way, you go back to that basics.
Over. Now forward. Over. Yeah.
Square it like this, and give me a hook. Hook. Jab, cross, hook, and then we'll go like this, all right?
1, 2, 3.
Now, what age might you consider to be old?
Probably 80 or 90. He could just do everything that I told him to do. An age that I would consider to be old now might be 100.
Do you remember what you said?
Yeah, I said in the 50s, I thought that would be old. But when I thought about it, like...
Wait a minute.
I'm sorry.
I can do it.
It really changed my thinking of what old is. You've taught me something today. Clearly, there's no way she's old, you know?
Now I know from today, hey, I don't look at age.
At my age, I feel like I did when I was in my 20s.
There's so many things that I still want to do. There's so many things that I can do. As long as I'm growing and learning, then age doesn't matter.
When people start stopping, that's when they start getting old.
Thank you. Thank you so much.
Thank you.
Okay.
Thanks, Daphne. It was great meeting you.
How long have you been doing this? Is this a new skill?
40 years.
Wow.
There's power to bringing people face to face with things that they might not fully understand or have these stereotypes about. And I think that video really captures so well a lot of the stereotypes that employers had and continue to have, sadly, in many different respects with respect to older workers. So in 1967, Congress enacts the Age Discrimination in Employment Act, which is the first federal level statute to try to create some level of equality for older workers. It was separate from Title VII of the Civil Rights Act. It's a separate statute, which has some advantages and disadvantages that we can talk about as well. But to look at what the power of the ADEA at the time. There's a quote here from President Lyndon B. Johnson when he addressed Congress and trying to encourage the Congress to enact the statute. He spoke of hundreds of thousands, not yet old, not yet voluntarily retired, who find themselves jobless because of arbitrary age discrimination. And the initial goal of the act focused on the hiring challenge because that was so obvious and blatant, as I mentioned before, where job ads were very clear that they didn't want someone above age X, oftentimes as old as 35. So you can see the purpose here of promoting employment based on ability rather than age. And I think that's always something that's helpful for us to keep in mind when we're thinking about why this matters. Right? We make assumptions about anyone for all kinds of reasons, but all that we are trying to do at AARP and AARP Foundation, I know so many of you who are involved in aging issues want to do, is to enable people to be judged based on their ability rather than age, and to maximize and fully develop their abilities and put them to good, productive, and valuable, rewarding use along the way. So here are some key provisions of the Age Discrimination and Employment Act. So you can see it applies to any term, condition, or privilege of employment. It started out principally as a hiring statute, but also applies to firing, promotions, layoffs, compensation, job assignments, training opportunities, everything that goes into being an employee in the fullest sense of the word. Age should not play a factor in any aspect of how you do your job, what you're allowed to do, not allowed to do. Again, ability, not just your age. Harassment is also covered by the ADEA, as is retaliation. So you can't be punished for raising your voice for age discrimination or filing a charge with the EEOC or participating in any investigation or a case. That retaliation is prohibited under the ADEA. And the most obvious problems of the pre-ADEA era of having expressed preferences or limitations in job ads based on age is also prohibited, but unfortunately not gone directly, as we will talk about as well. So as the ADEA took effect and employers and employees had experience with the federal statute, Congress recognized that there were some holes that it needed to fill, as it often does, and we enter into an age of various amendments. And this is partially rooted in, as we talked about earlier, people living longer and being able to and wanting to work longer. So the original ADEA protected you above the age of 40, but then stopped protecting you after 65. In 1978, Congress realized, well, just because you've hit 65 doesn't mean that you are not able or willing to work. And so we don't want to deny that protection. So they raised it to 70. And then in 1986, they said, why do we even stop it at 70? So there is no longer a maximum age for protection under the ADEA. And effectively, it gets rid of mandatory retirement for employees. So there used to be policies not that long ago in the grand scheme of history where an employer could just say, once you hit a certain age, you are done here. Those are generally no longer allowed under federal law. There are some statutory exceptions for some health and safety related jobs, law enforcement, firefighters, air traffic controllers, and certain exceptions that Congress has created. But if Congress hasn't created that exception, then you can't do that with respect to an employee under federal law. And state laws may also go well beyond that as well. So again, the ADEA is kind of the floor for protection for employees against discrimination, but state laws can also play an important role in a lot of this. In 1990, we look at not only the hiring, but also what about the benefits? And this was a statute that was enacted in reaction to a United States Supreme Court case where the court held that the statute, the original ADEA, didn't forbid age discrimination with respect to employee benefits. So health insurance, disability benefits, life insurance, retirement plans. And so the Older Workers Benefit Protection Act amended the ADEA to ensure that older workers are entitled to the same benefits regardless of age, also prohibited age discrimination and terminations, and again, trying to get more robust out of the initial mindset that this was very much focused on the hiring process, but really taking a much more holistic view of the employer-employee relationship and the importance of each of those components to older workers along the way. So we look at some of the Supreme Court decisions, and there have been several dozen interpreting the ADEA. And as often is the case with Supreme Court decisions, some are good, some are bad in terms of protecting older workers and the interpretation of the Age Discrimination and Employment Act. So Thurston in 1985 and Smith versus City of Jackson in 2005 both recognized that to protect older workers from discrimination, it's important to look not just at express discrimination, which is often called disparate treatment of older workers. In other words, something that is, I am not hiring you because you are above a certain age, or I'm not promoting you because you're too old and I think you're too close to retirement to be worth the investment, but also that you can have a disparate impact claim. which means that even if age is not expressly the criterion, if there are policies or practices that you have that disproportionately affect older workers, that you can still state a discrimination claim. And this is very common under the Civil Rights Act as well, because as the law evolves and society evolves, sometimes employers find other creative ways rather than saying expressly anyone over the age of X can't get this kind of assignment or can't be eligible for this kind of training or is ineligible for promotion. So these cases are important to broaden protections, the ability to assert your rights under federal law under the ADEA. In Meacham, the court recognized that the burden of proof when an employer wants to raise that an age discriminatory policy or practice of the employer is justified because it is based on a reasonable factor other than age, is the standard in the ADEA. Meacham held that the employer bears the burden of proof and persuasion that it was in fact a reasonable factor other than age at play. That's a big deal in the course of trying to assert your rights under a federal civil rights statute. Who bears the burden of proving and persuading? And so by placing that burden on the employer rather than the employee, as some of the federal courts had held, the court here is again having a pro-employee view of the ADEA. And then finally in Babb v. Wilkie, the court decided that federal employees at least don't need to prove that employment discrimination would have been different or an employment decision would have been different but for age, which is a little different from the private sector employment standard, which is coming up on the next slide. So again, thinking about what you need to prove, how much age needs to be a factor in the employment decision. In other civil rights contexts, you just need to demonstrate that a protected characteristic was at least a motivating factor, even if it wasn't the only reason, so that if you are older and Black and a woman, that any one of those things aren't good reasons to be discriminating on the basis in the course of employment. But we also have some not so good cases. In Gilmer, the court ruled that claims under the ADEA can be subject to mandatory binding arbitration. So if your employer, as part of your employment contract, has you in advance agree to arbitrate your employment claims, the court in Gilmer said that that was allowed. In Hayes and Paper, the court ruled that it doesn't violate the ADEA with respect to non-age specific, but highly age correlated criteria. So for example, in Hayes and Paper, firing an employee before they vested in for their pension, right? Very clear age connection. And so the plaintiff in that case was saying, hey, that's a violation of the ADEA. And the court said, it's age related, but it's not age specifically, and unfortunately allowed that kind of discrimination to not violate the ADEA. And then finally, in Gross, the court ruled that to prove violation of the ADEA, a private employee must demonstrate that age is the but-for cause of the employer's adverse decision. So unlike in Title VII with respect to race, for example, the burden of proof for an employee in an age discrimination claim or case is higher. We have been trying at AARP to initiate some legislative changes around each of those things that I will also talk about as we talk about some of the things that we are doing here at AARP and AARP Foundation. So some hot topics, just to touch on a few things that are important that we see in our day-to-day work and that we are looking at in terms of litigation as well as legislation. Disparate impact claims with respect to job applicants. I mentioned that there were a couple of Supreme Court cases that talked about being able to bring a claim for a policy or a practice that disproportionately impacts older workers, and that has been true with respect to current employees. not all courts are in agreement with respect to whether or not you can do that if you are a job applicant rather than whether if you are just a current employee, which is a significant problem to have that kind of inconsistency in approach to what should be a well and broadly protective civil rights statute like the ADEA. Technology and AI in the employment process, you know that there are so many ways that the workplace and the marketplace for good workers is dominated by technology, by tech tools, companies using AI and other vendors to screen job applicants and recommend who should be hired. And there's a lot of evidence to demonstrate that those algorithms and other means that get used to try to help find the right fit for an employer can be very discriminatory with respect to age. We also have seen in digital advertising targeting certain jobs only with respect to age, so that you will see certain ads if you are on Facebook, for example, only if you are below the age of 44, but if you are me, you won't get that ad. There's a lot of interest in intersectional discrimination, as I suggested before. If you have age and race and gender, what standard applies in that mix for someone who is trying to assert that they were discriminated based on a combination of protected classes and not any one of them necessarily. There's also an interesting case now against Yale that the EEOC has brought that we filed an amicus brief in concerning age-based cognitive testing for certain medical professionals, where without having any other reason to believe that you are not capable of doing your job or that you are doing something wrong, as a matter of policy, once you hit a certain age, you're going to have to go through a battery of testing that other people aren't. That's currently in court. And then, as I said earlier, arbitration is an issue that AARP is very interested in across the board. And the Protecting Older Americans Act has been introduced in Congress, strongly supported by AARP, that would invalidate mandatory binding arbitration in the employment context for age, much as it was done a couple of years ago as part of the Me Too movement, where they removed the ability to arbitrate certain sexual harassment claims, as an example. Our colleagues at AARP also have been strong advocates for trying to undo the damage of the Gross case that I talked about and making sure that the burden of proof for age discrimination is aligned with that of other protected categories, such as race, and also the Protect Older Job Applicants Act, which would make sure that we have disparate impact as an appropriate vehicle to challenge discrimination when it happens for a job applicant. Now I'm throwing a lot of different pieces out there for you in this very, very quick drive-by of 70 years of history of age discrimination as we move across the eras. And I wanted to just highlight some of the examples that my team at AARP Foundation, where we have the luxury of having a wonderful group of very dedicated lawyers and legal professionals who file lawsuits across the country and also file what are called friend of the court or amicus briefs in cases that other entities are bringing forward, other lawyers representing individuals or classes of individuals. And we are really very excited to get to work on these issues that are so near and dear to our hearts and so central to our mission. So you can see here that we have a number of lawsuits that have been in the last few years, some of which are still ongoing. Spirit Aerosystems with respect to discriminatory firing of older workers and not considering them for rehire and bringing younger workers on board instead. We recently participated in a charge against Facebook and Meta for discriminatory advertising on its platform so that only certain people can see ads. This is a wonderful case involving an organization called Real Women in Trucking And so the group of women truckers who were not getting Facebook ads because those ads were only going or principally going to people who were under the age of 55 and male. So again, a good example of that intersectionality that I was talking about. But there are plenty of people 55 and older who would be willing and able to take on a good trucking job if they were given the opportunity to do so. Raytheon is a case we filed recently with respect to one of those ways that employers can achieve a lot of the same ends as an express age limitation on employment by using certain buzzwords that you see in the graphic here in the case of Raytheon, looking at people for certain positions who are only within 2 years of graduating college or otherwise have no more than 2 years of experience for a job, which is going to have a disproportionate impact on older workers who may well be willing and able to have a really good job at a company like Raytheon, but are categorically denied because of the practices that they've instituted. Again, not specifically calling out age, but using something that does a pretty good job of weeding you out if you are above a certain age. And then Target and PwC are two cases that we were able to settle with respect to their employment practices. Of course, in neither case is there any admission of liability, but we were able to, in PwC, establish good case law with respect to the ability of a job applicant to bring a disparate impact case, as well as settle the case on behalf of the class of older workers who had applied for entry-level jobs at PwC. And with Target, our settlement enabled us to get some practices that Target committed to affirmatively be open and recruiting older workers as part of its workforce recruitment efforts. So incredibly proud of my team for doing the hard work. These cases can take a very long time. And one case that my team brought years ago is actually one of the largest class action settlements with respect to age discrimination involving more than 6,000 writers in Hollywood. Hollywood, a notoriously ageist environment for creative people, actors in particular, but also in this case, there was a quote unquote gray lining of writers and other off-screen talent that were not allowed to have opportunities to participate. So I thought this was another great video that AARP put together to highlight what old looks like in Hollywood.
Hey, old man! What are you doing here? You're too old for this.
Old. Old? Old.
I used to be with it, but then they changed what it was.
Too old to start a rock band.
Women aren't sexy when they're old.
We're looking for someone a little younger.
Face it, lady, we're younger and faster.
I can't fill up a space shuttle with geriatrics.
Getting old sucks.
Did you just call me old?
Sure, we're too old to change the world.
To build a really better world sometimes means having to tear the old one down.
You know, at my age, I only have one speed, breakneck.
Face it, girls. I'm older and I have more insurance.
High five.
And not that it matters, but I am 52 and I will rock this dress.
Look and learn, boys, because if you ask me, this is what cool is.
I love the expression own it. Own your age, I think, is so important. And I think that becomes a part of how one might think about approaching the job search and your job experience as you go forward. So I wanted to spend a little bit of time as we approach the close here to talk about some signs of age discrimination and some tips to address them should you see them? And here are just the 3 buckets where age discrimination can be most prevalent in the recruiting and hiring process, once you're on the job, and then the termination that we often see, a reduction in force where there is a disproportionate impact oftentimes on older workers relative to younger workers who were let go. So in recruitment and hiring, we see and hear all too often about job ads that have words that, again, are not expressly how old you are, but are giving some pretty good signals about being only a recent college graduate or a digital native, an energetic person, or having no more than X years of experience. Asking your date of birth up front as part of the application process, or even during the interview. So how old are you? Aren't you overqualified? That's often a favorite of people as well. Or can you really work for someone younger than you? And so all of these can be signs of ageism in the workplace or as part of the hiring process. And it is not illegal under federal law to be asked how old you are or what your date of birth is. There are some states, largely at AARP's urging at the state level, that do prohibit that upfront. So it is important to know where you are and where you're looking for your jobs. That state law protection can be greater than federal law generally, and with respect to asking about your age upfront in particular. But if you are asked, own it. I'm 55 years old, and this is what I've accomplished over the course of my X number of years career, and this is the experience, the knowledge, the skills and abilities that I bring to the table because of those years of experience. This is how those things will make your workplace better, right? To get back to a Hollywood kind of line, you want me on that wall, you need me on that wall because I have that experience, right? You have to own it at a certain level and make it not about age for them, but really get back to what are the skills that you have to offer? What is the value proposition that you bring to them given your age and your experience? On the job, we hear too often about coded and not so coded comments about needing some fresh faces or some new blood around here, jokes about senior moments, or people talking about not being able to teach old dogs tricks. People can't learn technology, etc. Again, promotions and training, all of those opportunities are also covered. There's a brand new AARP survey that we just did where of people who are 50 and older having observed or experienced having an employer assume that the older employees are less tech savvy, 33% said that they had observed or experienced it. 22% said they had observed or experienced not having the accomplishments of older employees recognized by their employer in the same way. 25% had employers assuming that the older employees are resistant to change. There are a lot of these stereotypes that come up in the workplace that are reflections of a lot of the stereotypes that we have that are ageist in society general. So I'll have one last video for you to share that I think, again, outside of the workplace, but also happens in the workplace that unfortunately is a reflection of a lot of the culture of ageism that still is pervasive.
I'll go. Come on, buddy. I'll go.
How you doing?
Hi, good.
Have you ever done this before?
No. It's exciting.
So tell me, how old are you?
19. 24.
29.
I'm 41. I'm going to be a mother for the first time. 42.
71. I'm 74.
I'm ready.
Okay, so we're just gonna talk. You're gonna show me stuff. Do I need my glasses?
I'm going to show you some slides, and I'd like you to fill in the blank and put the words "for her age" at the end of the sentence.
All right.
She has flawless skin for her age.
Beautiful for her age.
She looks better than most 20-year-olds for her age.
She looks great.
She is beautiful.
Fierce for her age. In burlesque, I love it.
That might be a little bit inappropriate for her age.
Jane looks amazing for her age.
She doesn't look her age. She's pretty hot.
For her age.
For her age. Her age. I'm going to show you some other slides now. So I'm just going to ask you to read the sentences that we provided for you.
Okay.
She dances well for a white girl.
That's not nice at all.
It's just ridiculous.
She's rich for an immigrant?
No, that's so gross. She's funny for an Asian.
Oh my God, they're getting worse.
Well, this girl's half Asian, and me and her dad are pretty freaking funny, so she's gonna be funny.
She's pretty for a thick girl. I hate that. You should not be defined by your size. Yeah, I hate that.
She drives well for a woman.
You can't think like that. And then you bring up your kids like that. Then you have a society like that. We got another one? Is it gonna be worse? There we are.
She looks good for her age.
So I didn't expect this to fall apart.
They're all the same, narrow-minded and ignorant.
I'm guilty. I say for her age all the time. It's harder to look good in your late 40s. You can be hot at 23 and you just roll out of bed.
Sometimes I think it's good and sometimes I don't.
I didn't realize I was really insulting anybody because it's only because if someone says it to me, I think it's good.
It's not a compliment.
It's really like a backhanded compliment.
I think it is a bias. People are definitely labeled by their age.
I guess for her age is more commonly accepted. This is okay to say.
Which is like, why?
You look good is a lovely compliment, but to qualify it, you're saying, well, in comparison to the mainstream of beauty, you don't look good, but you look good for how old you are.
It's degrading.
I think everyone should understand this. I think people be treated differently.
Say you look good, period. You know, don't add for her age.
No, I'm going to leave the for your age part off.
Unless you're asked these questions, I don't think you have the mind to start this conversation.
You know what? Everyone's going to get older.
Again, I think a powerful reminder of how even outside of the work environment, we have so far to go in fighting stereotypes and generalizations. The workplace is just a reflection of broader society in many ways, and it's unique and has particularly difficult issues to grapple with when you experience it in the workforce. But there's so much of that that really is cultural for all of us to be fighting back against. A colleague of mine used to talk about protection from age discrimination as being a second-class civil right, because we tolerate things about age that we would never tolerate with respect to race, ethnicity, religion, sex, gender, sexual orientation, for example. But somehow something about aging seems less serious for too long. And I think it's up to all of us to really put a stop to that kind of thinking and challenge those outdated stereotypes about older people in the workforce and more broadly. So just to leave you with some tips about what to do if you find yourself or know of someone who may be experiencing age discrimination in the workplace. Know your rights, keep a log, write things down, do it contemporaneously while memory is fresh. Bring it up first and formally with a supervisor. If that doesn't work, you need to go through the formal process the employer may have, whether that's through HR or a higher level manager. Talk to a lawyer if you think there's something that you want to pursue beyond that. You don't need to have a lawyer to file a complaint with the EEOC, but still can be helpful for you to understand what your options are. You can file a lawsuit after you have filed a complaint with the EEOC. You have to file with the EEOC first before you can file a lawsuit in federal court, and there are strict time limits with respect to filing that complaint after a discriminatory action has taken place. So check the EEOC.gov website for further information about that. And again, own your age. You are entitled to a level playing field, and you need to be able to stand up for yourself and others to make sure that that happens. So we have some resources for you and the handouts and material that I think will be available, or I can make available to you, both with respect to generally around age and as well as being able to assert your legal rights, as well as AARP resources for you as employers. So again, thank you to Benjamin Rose. Thank you to all of you for sharing this time with me. Sorry for the initial audio glitch, but I'm glad that we were able to get that fixed.
Thank you, Bill. Wonderful presentation, and those videos were really so powerful. Every time you showed one, we had just such wonderful feedback about how it really, hit the points you were trying to make.
Great.
So, going back to the tip sheet, um, we did have a comment that came in that said, while there are laws prohibiting age description, that this participants come to understand that the complainer must demonstrate that age was a primary reason for the action, and that proof could be pretty difficult to produce. Do you
Yeah,
have any further?
it is hard to bring a case or a complaint. There's no question, but that's why it is so important to document what you see. Who was there with you? I was there in this place, right? Where? The classics. Who, what, where, right? What happened? I was here. My boss said this happened, and you document it in real time while memory is fresh. Talk to somebody contemporaneously, right? The best you can do is gather the best evidence that you have of whatever it is that you think was done wrong to you. But it is certainly age discrimination and all forms of discrimination. They're difficult cases to bring, there's no question. But as you saw, 14,000 complaints are made every year with the EEOC just on age, and that's tip of the iceberg, right? Most people aren't going to file that charge, but you need to file a charge to file the lawsuit, and the lawsuits are ultimately, and the EEOC charges do change behavior a lot of the time.
Thank you. And you did talk a good bit about intersectionality, and we did have a comment that came in, and this participant asking, how do you know that it's just age discrimination rather than an intersection to include race, immigration status, or identity?
Well, I guess I always start with trust your uh-oh feeling, right? I mean, part of it is what is it about the behavior or the words or the actions that took place that are bothering you, right? What are you noticing, right? And think in detail, again, thinking about the documentation in real time while things are fresh. Write down what it is that you're feeling about that and why you think that that particular action may have been related to your age or your race or your ethnicity or your gender, right? If you notice that, well, younger women are doing okay and older men are doing okay, but older women aren't doing okay, right? This is an example of that intersectionality where somebody can say, well, it's not age, the old guys were fine, right? We don't see any promotional problems there. And somebody say, well, it's not gender because all these, younger women seem to be thriving and being promoted. But if you're in that box where you're older and a woman, this is Hollywood being a classic example of this, right? Where you have that intersectionality, that it's that you're a woman and you're older. That's the challenge that you're trying to address in that situation. But again, the best you can do is try to gather as many pieces of evidence as descriptively and in real time as possible.
Thank you. We just want to emphasize again that a copy of the recording will be sent out as well as the slides, and it will include those wonderful resources that Bill provided us with, so everyone will be able to refer to those and share the presentation and share the resources with their family, friends, or coworkers, and just we will make sure that those are available in the next coming days. We did want to, again, thank you, Bill, for just such a wonderful, impactful presentation. I know that so many people just gave wonderful feedback. It really just hit home in all of those areas that you emphasized, and perhaps we hadn't given as much thought to age discrimination in the workplace as we will now. So it's a really great takeaway, and we really appreciate your time and making this presentation.
Great. Well, again, my thanks to Benjamin Rose, Bob, our wonderful leader on the AARP Foundation Board of Directors, and my wonderful litigation fellow, Sydney Bruno Zunu, who helped me put together the presentation. Very grateful to have this opportunity to share with your audience something that we obviously are very passionate about, that we think is really important for everyone.
Thank you. And we do want to thank everyone for joining us today for this webinar, Age Discrimination in Employment, the Eras Tour. Us Swifties really appreciated all those wonderful Taylor Swift references that you gave throughout the presentation. So thank you for that as well.
Great. I'll leave you with one more from my girl Taylor here. So deep deep love for Taylor, right? So deep
We
love.
love it. All right, so in the chat, you will now find a link for a webinar evaluation that we hope you will complete. Your feedback is important to us as it does help us improve our programming. Please keep in mind that your responses will be kept confidential and will not identify you in any way. We hope that you will join us for future events like this one, including every second Wednesday of the month from 9 to 10 a.m. Eastern Standard Time. You can join us virtually to learn more about Benjamin Rose and to hear from our president and CEO, Orion Bell. Each month, we will provide an overview of the programs and services we offer. Second Wednesdays are a great opportunity to network, as I mentioned, learn more about Benjamin Rose and discover how you can get involved in our work. The next session will be held 1 week from today, so next Wednesday, October 9th. Please also join us for the Financial Fatigue of Caregiving workshop, which is held every third Monday of the month via Zoom. The next session will be on Monday, October 21st from 12 to 1. This free workshop addresses the financial fatigue experienced by caregivers and provides practical strategies and resources to help them navigate these challenges effectively. Lastly, we hope you will save the date for our annual caregiving conference on Friday, December 13th from 9 to 4. It will be in person at two great locations, the Benjamin Rose Conference Center here in Cleveland and the Golden Buckeye Center for Dementia Caregiving at The Ohio State University in Columbus. Our topic this year will be Components of Quality Dementia Care, and will feature Dr. Gary Epstein-LeBeau as keynote. And he's going to be discussing the role of the guide model in improving access to dementia caregiving resources. This year, the conference includes a jam-packed agenda featuring initiatives both locally and nationally to improve dementia caregiving. Registration will be available soon on our website. So, as I mentioned, there are many different events going on. You can register for these and all of our upcoming events on our website, www.benrose.org. There you can also find more information about all of Benjamin Rose's research, services, and programs. We thank you for joining us, and we hope that you have a great rest of your day.